Before you walk into a courtroom or sign anything in a divorce, there is one question that weighs heavily on almost everyone's mind. What happens to the property? Who gets what? The house, the savings, the car, the business, and maybe even the dog. In 2025, property division after divorce in the United States has evolved with new types of assets, new interpretations of fairness, and a growing focus on financial transparency. Whether you're planning for divorce, in the middle of it, or simply trying to understand how the system works, this video will break it all down clearly and accurately. You do not want to guess your way through this. The outcome can affect your finances for the rest of your life. So stay with me. Welcome back to U.S. Family Law Advisor, the channel where we translate complex legal concepts into clear, actionable guidance for real people going through real family law issues. I'm your host, a family law attorney and advisor with over a decade of experience guiding clients through the toughest moments of their lives. And one thing I've learned is this: understanding how your property will be divided in a divorce isn't just important, it is essential. Too many people walk into divorce blindly, expecting everything to be fair or automatic. But that's not how it works. The legal system doesn't operate on assumptions or emotions. It operates on laws, facts, and documentation. So let's walk through how property is divided after divorce in the U.S. in 2025 and what you absolutely need to know to protect your financial future. First, it's critical to understand that property division laws are not the same across the country. Each state follows its own rules. But there are two primary systems that states use: community property and equitable distribution. These systems determine how courts divide assets between spouses during a divorce. And the difference is more than just legal jargon. It can dramatically impact what each spouse ends up with. In community property states, the law assumes that both spouses equally own any property or income acquired during the marriage. That means everything, from salaries to real estate to stock portfolios, is split right down the middle. 50-50ths as of 2025. 9 states follow this model: California, Texas, Arizona, Nevada, Washington, Idaho, Louisiana, New Mexico, and Wisconsin. Alaska also allows couples to opt into a community property agreement, though it's not the default. This system may sound straightforward, but even in community property states, there are exceptions and gray areas. For example, if one spouse owned a home before the marriage, but the couple lived in it during the marriage, and both contributed to the mortgage or renovations, that separate property might be partially converted into community property through something called commingling. And this brings us to one of the most important concepts in any property division case: the difference between marital property and separate property. Marital property includes almost everything acquired by either spouse during the marriage, regardless of whose name is on the title or account. This typically includes income, homes, cars, retirement accounts, investments, businesses, and even debts if they were accumulated during the marriage. Separate property, on the other hand, includes anything one spouse owned before the marriage, as well as gifts and inheritances received by one spouse individually during the marriage. But here is where people often get tripped up. If you don't keep your separate property truly separate, for example, if you deposit inherited money into a joint account, or use it to make improvements on a jointly owned home, that separate property can become marital, either partially or fully. That's called commingling, and it's one of the top reasons why people lose assets they thought were protected. Now let's talk about the majority of states which follow equitable distribution. In these states, property is divided fairly, but not necessarily equally. Let me give you a real-world example. Imagine one spouse stayed home for 15 years to raise the kids while the other worked full-time and built up a strong retirement account. In a community property state, the retirement account would likely be split 50-50ths. But in an equitable distribution state, the court might award a larger share to the non-working spouse to account for their sacrifices and future need. On the flip side, if one spouse emptied a joint bank account right before filing for divorce, a judge could factor that misconduct into the property division and award the other spouse a larger share. That brings us to another key point in 2025. financial transparency is more critical than ever. With the rise of digital banking, cryptocurrency, and online-only investment accounts, courts are seeing more and more cases where assets are hidden or misrepresented. If a spouse fails to fully disclose all their property, including digital assets like Bitcoin, NFTs, or online businesses, they can face serious legal consequences. Courts now have digital forensic tools and expert witnesses who can track down hidden wealth. So here is my advice: don't try to hide anything, and don't assume your spouse isn't. Get full financial disclosures and work with an attorney who understands how to trace digital and complex assets. Speaking of modern assets, let's take a minute to talk about retirement accounts and pensions. These are often among the largest marital assets and require special attention. In most cases, contributions made during the marriage, whether to a 401k, IRA, or traditional pension, are considered marital property. To divide them, you'll often need a legal document called a Qualified Domestic Relations Order, or QDRO. This allows for the transfer of retirement funds between spouses without triggering taxes or penalties. Without a QDRO, a rollover could be taxed as a distribution, leaving you with less than you expected. Now let's look at the marital home, often the most emotionally and financially significant asset. Who gets the house depends on a variety of factors. Sometimes one spouse keeps the home and buys out the other's share of equity. Other times, the home is sold and the proceeds are split. In cases involving children, courts often lean toward awarding the home to the parent with primary custody, at least temporarily, to provide stability. But remember, keeping the home also means keeping the mortgage, taxes, and upkeep. Always think beyond ownership, think affordability. Debt is another big piece of the puzzle. Just like assets, debts are divided based on whether they're marital or separate. Credit card balances, student loans, mortgages, medical debt. If they were acquired during the marriage, they're usually shared. However, courts may assign certain debts to the spouse who benefited most or who is better positioned to repay them. One common scenario is one spouse taking on more debt in exchange for more assets, especially when trying to equalize a settlement. Prenuptial and postnuptial agreements can also play a huge role in property division. These legally binding contracts can define in advance how assets and debts will be handled. In the event of divorce, in 2025, prenups are more enforceable than ever, as long as they meet the legal requirements of your state. That typically includes full disclosure, no coercion, and fairness at the time of signing. A good prenup can protect business interests, family inheritances, or future earnings, but it must be properly drafted. DIY templates often fall short, and the consequences can be massive. Here is another modern development in 2025. More couples are using mediation or collaborative divorce to settle property division outside of court. These methods give you more control, cost less, and often result in less hostility. If you and your spouse can communicate reasonably, I strongly recommend exploring out-of-court options. You can still consult an attorney to ensure your agreement is legally sound and that your rights are protected. And if things do need to go to court, having clear records and realistic expectations can make all the difference. There are also significant tax considerations during property division. Transfers between spouses under a divorce decree are generally non-taxable, but selling property, cashing out retirement accounts, or keeping a home that's later sold at a gain can trigger tax liabilities. That's why it's essential to work with both a lawyer and a financial advisor. A settlement that looks good on paper can hurt you long-term if you don't consider taxes, liquidity, and future growth. Ultimately, the most successful divorces, financially speaking, are the ones where both spouses are informed, prepared, and honest. Whether your divorce is amicable or contested, remember this: property division is not just about what you own now. It is about your financial future. Take the time to understand your rights, gather your documents, value your assets properly, and get qualified advice. If there's one thing I want you to take from this video, it's that knowledge is power. Don't assume anything. Don't sign anything blindly. And don't go it alone. You only get one shot at dividing your property fairly. Make sure you do it right. Thank you for watching U.S. Family Law Advisor. If you found this video helpful, please give it a like, subscribe to the channel, and hit the bell icon so you don't miss any of our upcoming videos. We're here to empower you with clear, current, and credible legal insight every